Imagine logging into your bank tomorrow morning.
Right, just a normal day.
Yeah, but then you find your entire life savings just completely exposed to the public, all because of like a massive server failure.
Oh, wow. That is a total nightmare scenario.
Right. But then imagine realizing the law just legally stripped away your right to sue that bank for the damages. You are financially ruined, and the court system's doors are, well, they're basically locked from the inside.
I mean, it sounds like a dystopian novel, but that specific scenario, that sudden evaporation of individual legal recourse, is precisely what some of the most prominent civil liberty advocates in the country are claiming is about to become a harsh reality.
Okay, let's unpack this. Today is Tuesday, May 5th, 2026, and we're looking ahead to next week, specifically May 13th, 2026.
That's right, the big day.
Yeah, the Supreme Court of India is preparing to examine the very foundation of how our digital lives are governed. The target of this really high-stakes legal showdown is India's Digital Personal Data Protection Act of 2023.
Which we'll just call the DPDPA for short.
Exactly. The DPDPA and its newly minted 2025 rules.
And honestly, the outcome of this single hearing will fundamentally define the digital landscape of the entire country for a generation. I mean, it is a monumental test of constitutional law.
It really is.
Yeah.
And so our sources for this deep dive consist of this massive stack of legal petitions, court schedules, and formal intervention arguments.
It's a lot of reading.
It is a ton of reading. So our mission today is to extract the core arguments from these incredibly dense legal filings. We want to understand exactly why some groups are calling for this law to be entirely scrapped and, why others are fiercely defending it.
And to be clear to you, the listener, we are doing this without taking any political sides.
Exactly. We are simply, impartially, unpacking the complex legal philosophies at play here. Because while this might sound like abstract legal jargon, this case fundamentally dictates how your personal data is treated.
Yeah, how it's protected or potentially exposed online.
Right.
That neutrality is vital, by the way, because the legal theories clashing in these documents are fundamentally opposed. Both sides present these intricate, really compelling arguments about how a modern society should balance state security, corporate responsibility, and individual liberty.
Yeah, especially in the digital age.
Yeah.
But before we dissect the blueprints of the law itself, we need to understand the sheer scale of this upcoming May 13th hearing.
Right, the battlefield itself.
Exactly. We're talking about a heavyweight legal battlefield here.
Oh, absolutely. The bench hearing this case is headed by the Honorable Chief Justice of India, sitting alongside Justice Joymalia Bagchi and Justice Vipul M. Pancholi.
That's a serious lineup.
It is. I mean, when a three-judge bench led by the Chief Justice takes up a matter, it signals immediately that the Supreme Court views this not just as like a routine regulatory dispute. It's a matter of immense constitutional gravity.
And the groups bringing these petitions forward are heavy hitters too, right? In the civil rights space.
Oh, totally.
You have the National Campaign for People's Right to Information, the Reporters Collective, Venkatesh Nayak, and Gita Seshu.
And our sources note they aren't just asking the court for a few minor edits or, clarifications to the text.
No, not at all. They are bringing what the documents call serious prayers to the court.
Right. And in legal terms, a prayer is the specific relief that a party is asking the court to grant.
Okay, so what exactly are they praying for here?
Well, in these four combined petitions, the primary prayer is the complete and total scrapping of both the DPDPA and its associated rules.
Wow.
Yeah, they want the entire framework declared void.
Which means we have a massive battery of well-known lawyers stepping into the ring to fight this out.
Oh, yeah. The representation is top tier.
So the petitioners are represented by leading advocates like Indira Jaising and Abhishek Manu Singhvi. And then on the flip side, defending the law for the government, you have Solicitor General Tushar Mehta.
Right, the state's highest legal defender.
Exactly. And then there are intervention advocates too, like Dr. Mahendra Lamai.
Yes, he's representing the Foundation of Data Protection Professionals in India, or the FDPPI.
Okay, so the caliber of that legal representation perfectly mirrors the stakes of the legislation.
It really does. You have state power facing off against some of the most prominent advocates for civil liberties.
So if we try to visualize what is actually happening here, let's look at the DPDPA, like a brand new digital traffic system for the whole country.
Okay, I like that analogy.
It's a system meant to regulate how data flows.
Right.
Who has to stop, who gets to go, and who gets a ticket. So if this is a new traffic system, are the petitioners basically arguing that the traffic lights are rigged to let the government speed through while crashing civilian cars?
That is actually a very accurate way to frame it. Laws of this magnitude naturally create friction between state power and individual rights.
Sure.
But the argument presented by the petitioners is that this specific framework tips the scales so far towards state power that it breaks the constitutional boundaries.
Breaking the boundaries, how exactly?
Well, they argue the system is designed to police citizens and private companies while giving the state an absolute free pass.
Okay, so let's move from who is fighting to exactly what they're fighting over. Why do these groups believe this new digital traffic system violates our foundational rights?
Right, the core of the constitutional crisis.
Yeah. The petitions, specifically those from Geeta Seshu and Venkatesh Nayak, point directly to Articles 14, 19, 21, and 21A of the Constitution.
And those articles, I mean, they are the absolute bedrock of Indian civil liberties.
We are talking about the right to equality before the law, freedom of speech and expression, the protection of life and personal liberty.
Which inherently includes the right to privacy, by the way.
Exactly. And the right to education. Claiming a law is ultra vires, meaning it goes beyond the legal power granted by these constitutional articles, is the most serious challenge you can mount in Indian jurisprudence.
It really is the nuclear option in a legal challenge.
So the first major mechanism they point to as proof of this overreach is Section 17, specifically subsection 2.
Ah, yes. The government exemption.
Right. According to the filings, this section allows the central government to exempt any of its own instrumentalities from the application of the Act and its rules. What does that actually look like in practice?
Well, what's fascinating here is the mechanism of immunity. If we use your traffic system analogy, Section 17.2 is essentially a mechanism that sets up a nationwide speed limit but gives government vehicles an invisible shield.
So the speed cameras don't even register them.
Exactly. The cameras don't even see them. The petitioners argue that if the government can simply exempt its own intelligence or administrative agencies from data protection rules, the law completely fails to protect citizens from state surveillance.
It creates a double standard.
It creates a paradigm where the strict rules of data handling only apply to private companies, leaving the state's massive data gathering apparatus entirely unchecked.
Wait, but if the government can exempt itself, what happens when a private company, someone who isn't exempt, inevitably messes up? This brings us to Section 44, subsection 2, Clause A.
This is a huge point of contention.
The petitions state that this section extinguishes the right of affected persons to seek compensation or a civil remedy for the unlawful processing of personal data, or a data breach.
Yeah, and this is perhaps the most visceral point for the average citizen. Historically, if someone harms you through negligence, say a hospital recklessly exposes your private medical records.
Right.
Well, tort law allows you to go to a civil court and sue for damages to make you whole again.
So what does this all mean for the average person? If my personal data gets hacked tomorrow, are the petitioners saying this new law literally strips away my right to sue for damages?
This raises an important question about how the law actually functions on the ground. And according to their reading of Section 442, yes. The petitioners argue that the law actively disarms the citizen.
This completely takes away that tool.
Exactly. If a company negligently exposes your sensitive data, this section allegedly removes your ability to demand personal compensation for the specific harm that breach caused you.
But doesn't the company get fined?
Oh, they might get fined by the government, sure. But that money goes straight to the state treasury.
Yeah.
It does not go into your pocket to help you recover from, say, identity theft.
Wow. So a government agency passing a law that strips away a citizen's civil compensation feels like a massive shift away from restorative justice.
It absolutely is a shift, and that is exactly why the petitioners are calling it a constitutional crisis. But, the structural changes don't stop with civil remedies.
What else is there?
Well, Venkatesh Nayak and others specifically target Section 44, subsection 3, arguing that it creates a devastating collision with the Right to Information Act, the RTI.
The RTI. I mean, that was revolutionary when it came out in 2005.
It totally changed the game.
It basically gave any citizen the power to pry open government records to ensure accountability. How does a data protection law dilute that?
Well, it's a clash of two different transparency paradigms. The RTI is designed to force information out into the open, but data protection laws are designed to lock personal information down.
Okay, I see where this is going.
Yeah, the mechanism of the collision is fascinating. The petitioners are arguing that the DPDPA is drafted so broadly that bureaucrats can now use personal data protection as a legally sanctioned excuse to deny legitimate RTI requests.
Let me see if I have the mechanics of this right. If a journalist uses the RTI to ask for the financial records of a corrupt government official to prove they are embezzling public funds.
Right, a classic investigative use case.
The government could theoretically use the DPDPA as a shield. Like they could just say, sorry, that officials' bank details are protected personal data. Request denied.
That is the exact fear outlined in the petitions. It turns a privacy shield into a cloak for corruption.
That is wild.
The petitioners argue this effectively plunges government operations back into the dark ages by legally overriding the transparency mandate of the RTI.
And that lack of transparency leads right into their next major challenge, right? The oversight mechanism itself.
Yes, the Data Protection Board.
The referee of this new digital traffic system. The petitions challenge sections 19 and 24, which govern how this board is constituted. Gita Seshu's petition specifically demands a mechanism that ensures the board's independence from executive control. Why are they so concerned about the board's makeup?
Mostly because of how the appointment and removal mechanisms function. If the executive branch has unchecked power over who sits on the Data Protection Board, how much they get paid, and how easily they can be fired.
The board can't be truly independent.
Precisely. The petitioners are pointing out that a referee whose salary depends on the government is highly unlikely to blow the whistle and impartially penalize government agencies that violate data norms.
So the referee is essentially on the payroll of one of the teams playing the game.
That's the argument, yeah. And there is one more critical piece to the petitioner's playbook, particularly from the Reporters Guild and Gita Seshu. They are fiercely criticizing Section 7 for lacking something very specific. Exemptions for processing personal data for journalistic, editorial, investigative, and public interest reporting purposes.
Oh, because journalists have to handle a lot of data.
Exactly. The mechanism of investigative journalism relies heavily on processing personal data without the subject's consent. Think about it. A journalist investigating corporate malfeasance isn't going to ask the corrupt CEO for consent to analyze their leaked emails.
Right. They just say no.
Of course. So without an explicit exemption in the law, journalists could be severely penalized for simply handling the personal data of the bad actors they're trying to expose.
That effectively weaponizes the data protection law against the press.
It creates a severe chilling effect. It threatens the vital protection of journalistic sources and, by extension, undermines the functioning of a transparent society.
Man, when you lay the mechanics out like that, the invisible shield for government exemptions, stripping away civil remedies, turning the privacy law into an anti-RTI cloak, a captive referee board, and the threat to investigative journalism, it really does sound like a full-blown constitutional crisis.
The petitioners definitely paint a deeply concerning picture of a surveillance state masquerading as a data protector.
Yeah.
However, as we noted at the beginning, our mission is to look at all the source material impartially. And there is an entirely different legal philosophy at play here, one that views the petitioner's panic as fundamentally misplaced.
Right. To ensure we are seeing the whole board, we have to pivot to the counter-argument. We need to look at the defenders of the law.
Yes, specifically the intervention filed by the FDPPI.
The Foundation of Data Protection Professionals in India.
That's the one. And the publicly available views of a digital law expert known as Naavi, which are extensively detailed in our source materials.
The FDPPI and Naavi present a defense that challenges the very premise of the petitioner's argument, don't they?
They do. Their core assertion is that there is no constitutional crisis whatsoever.
Their argument is fascinating because it doesn't just disagree on the details. It disagrees on the fundamental reality of what this law even is. They state that the objections raised by the petitioners are born out of a misreading of the Act and the rules.
It is a profound shift in perspective. The defenders concede that the government could easily issue a few administrative clarifications to allay some of these disproportionate fears.
Just a few tweaks.
Right. But they emphatically state that scrapping the law is entirely unnecessary and legally unsound.
And here's the core philosophical defense they offer, which honestly completely flipped how I view this law. According to Naavi's analysis, the DPDPA does not even claim to protect the overarching constitutional privacy right.
That is the category error the defenders are highlighting.
Oh, interesting.
Yeah, we are so conditioned to hear Data Protection Act and immediately assume it means Comprehensive Constitutional Privacy Act.
Right, you just assume it covers everything privacy related.
Yeah. But the defenders argue that the DPDPA is strictly an administrative scheme. It is uniquely designed to provide a framework for the enforcement of data protection by imposing administrative penalties on what the law calls data fiduciaries.
Okay, let's break down that term because it feels central to their whole defense. What exactly is a data fiduciary, and how does that differ from just any company holding my data?
A fiduciary legally owes you a duty of care. It means they aren't just a passive warehouse holding your data. They are legally bound to protect it, much like a bank is bound to protect your money, or a doctor is bound to protect your health.
Nice.
The DPDPA is designed purely to regulate how these specific fiduciaries operate and to fine them administratively if they breach that duty of care.
Here's where it gets really interesting. Let me try to wrap my head around this. It sounds like complaining your toaster doesn't make coffee. Naavi is arguing the DPDPA is just a toaster. It is built to do one highly specific thing, which is discipline data fiduciaries with administrative penalties. And if you want coffee-like, if you want to enforce your fundamental constitutional right to privacy and get individual civil relief, you don't throw out the toaster, you just use your coffee maker.
If we connect this to the bigger picture, that analogy holds up perfectly. The defenders are outlining a dual-track legal system.
A dual-track system, okay.
Track 1 is the DPDPA. It is the state acting as an administrative disciplinarian, rapidly levying heavy fines on companies that fail to secure their data infrastructure.
But the fine goes to the state, not to me.
Correct, because Track 1 is about systemic discipline. Track 2 operates entirely outside the boundaries of the DPDPA.
Okay, so what is Track 2?
Track 2 is the citizen utilizing the Information Technology Act of 2000, the ITA 2000.
Oh, an older law.
Yes. Along with traditional tort law and the constitutional right to privacy, you use those to seek individual relief, compensation, and damages in a civil court.
Wait, so if my data gets hacked, the defenders are saying the system is actually working as intended.
Exactly. The DPDPA quickly finds the company to punish them administratively, while you separately use the ITA 2000 to sue them for your own financial compensation.
Wow. And our source material highlights that this is not some radical, untested legal theory invented to defend a flawed law, right?
Not at all. Naavi indicates that this dual-track separation handling systemic administrative penalties in one realm and individual privacy relief in another is the exact same principle adopted by the European Union's GDPR.
The GDPR. So they're modeling it after Europe's system.
Essentially, yes. The idea is that digital law is supposed to be a web of overlapping statutes.
It's not supposed to be a single silver bullet that solves every digital grievance. The DPDPA is just one tool in the toolbox, and the petitioners are demanding it be thrown out simply because it isn't a Swiss Army knife.
That is the essence of the misreading argument. If you evaluate a targeted administrative penalty scheme by the standards of a comprehensive constitutional privacy guarantee, of course, it will appear deficient.
Right. It'll look like it's missing huge pieces.
It will look like it's stripping away rights. But the defenders argue it was never meant to be that all-encompassing guarantee. It inherently relies on the broader legal ecosystem, like the ITA 2000 and the RPI, to provide complete justice.
But what about the RTI collision? The petitioners argue the DPDPA creates a cloak for corruption. How do the defenders justify that part?
Well, the defenders would argue that administrative clarifications can easily instruct bureaucrats on how to balance RTI requests against data protection.
So just add some guidelines.
Exactly. They believe the fear that the entire RTI framework will collapse is a massive overreaction to a law that just needs precise operational guidelines, not total nullification.
This completely changes the landscape of the May 13th hearing. We aren't just looking at a debate over a few specific clauses. We are looking at a fundamental clash over how laws should be structured in the digital age.
It is a battle of legal interpretation and structural philosophy. Do you view the law in isolation, where its perceived gaps look like unconstitutional sinkholes that threaten democracy?
Right.
Or do you view it as part of a larger, specialized statutory mosaic, where the gaps in one specific law are purposefully left there to be filled by the provisions of another?
That is a really tough question. As we wrap up this deep dive into the source material, let's bring it all back to that impending showdown next week.
Yeah, the Supreme Court of India is going to have to decide between these two starkly different realities.
The bench will have to determine which interpretation holds water. Is this law a genuine constitutional threat that actively strips away transparency, endangers investigative journalists, and removes civilian compensation?
Or is it merely one highly specialized piece of a larger regulatory puzzle that simply needs a few administrative clarifications rather than total destruction?
And remember, the outcome of that decision directly impacts you. It decides the rules of the road for that digital traffic system.
Absolutely.
It dictates exactly how your digital footprint will be governed, who can legally access it, and the precise mechanisms available to you when those invisible walls around your data are inevitably breached.
It is a case that will unequivocally define the boundaries of digital sovereignty, corporate liability, and individual rights in India for decades to come.
Which leaves us with a critical, kind of provocative question to consider as we watch this historic legal battle unfold.
What's the question?
If a national data protection framework deliberately separates the idea of systemic data management from the fundamental human right to privacy into completely different legal realms, does that make our digital lives safer through specialized enforcement? Or does it just make it vastly more complicated for the average citizen to navigate the legal maze and defend themselves?
I mean, it is the defining paradox of our modern digital architecture.
It really is. Thank you for joining us as we explored the blueprints of this legal battlefield. We will be watching the May 13th hearing very closely. Keep questioning the invisible architecture around you.